If a will makes a charitable disposition of a person's property, it's not uncommon for the will to also include specifics about how the property should be used. But what happens if it's impossible or impracticable to comply with those specifics after the person's death? In Herbert Neher's will, we explore whether courts can reform certain specifics of a charitable devise to prevent a testator's gift from failing. Ellen Neher's will devised her house and its surrounding land to the village of Red Hook. The property was to serve as a memorial to Neher's late husband, and, to that effect, the will instructed that the property be used as a hospital known as the Herbert Neher Memorial Hospital. Under the will's terms, the village trustees would have the authority to manage and operate the hospital for the benefit of the community as a whole. After Neher's death, her will was admitted to probate, and the village agreed to accept the devised property. But a few years later, the village filed a petition in the surrogates court, the state court responsible for probate matters, seeking reformation of Neher's devise. The village explained that it lacked the necessary resources to construct and operate a hospital. Additionally, such a facility was no longer necessary because a recently constructed hospital in a nearby village sufficiently met the community's medical needs. Because establishing a hospital on Neher's former property was impracticable, the village asked the court to reform the relevant will provision to allow the village to instead use the property as an administrative building, which would be designated as Herbert Neher Memorial Hall. The surrogates court denied the village's request, holding that such a reformation would go against Neher's stated testamentary intent. After the appellate division affirmed, the village appealed to the New York Court of Appeals, the state's highest court.